Thank you everyone for joining us for the next edition of our OG Energy Education Series. My name is Patrick Schenkel. I'm a partner here at Oliva Gibbs, and I'm going to be presenting on kind of an interesting topic today. The title of my presentation is New Solutions for Old Units, How to Navigate Drilling Longer Laterals in Texas and Louisiana. So a couple topics that we will be discussing today. We're going to do a quick discussion of differences between Texas and Louisiana oil and gas law. It'll be very quick and brief. Obviously, we could devote a couple whole presentations to just the differences between Texas and Louisiana oil and gas law, but we're just going to touch on just a few subtle differences that'll kind of inform our rest of the PowerPoint. We'll also be going into depth on the background of pooling in Texas and Louisiana, specifically forced pooling in both states or compulsory pooling. Next, we will be touching on what are allocation wells and what are production sharing agreements, why those exist, kind of how they came about. Then we will touch on cross-unit wells. Next, then will be the impact of allocation wells and those cross-unit wells on horizontal drilling, kind of the new age of drilling now and kind of how that informs these drilling of allocation wells and cross-unit wells. And then last, we will touch on the allocation of production for allocation wells and cross-unit wells. So how are you supposed to allocate production for all the parties from those wells? First, some quick terminology differences between Texas and Louisiana. As we said, there's a lot of differences between them, but just a few subtle ones here to begin. Texas, you have counties. In Louisiana, they refer to them as parishes. In Texas, you have the mineral estate. In Louisiana, they do not have a separate mineral estate. They do not recognize kind of a separate mineral estate. The mineral rights cannot be severed from their land rights. They have what's referred to as a mineral servitude. We won't be touching on that today, but we could do a whole other presentation, obviously, just on mineral servitudes. Another difference is Texas is a common law state, like every other state in the United States, while Louisiana recognizes civil law. More of the French, Spanish system of laws. There's also real property and personal property in Texas versus a different way to refer to them in Louisiana. You either have a movable or movable, incorporeal or incorporeal. Texas has deeds of trust. Louisiana, they refer to them as mortgages. Texas, there's a life estate. Louisiana has a similar concept, but it's subtly different, called usufruct. And then Texas, you have probate. Louisiana, you have succession. And these are just a quick couple terminology differences, just to let people know. Another major difference between Texas and Louisiana is kind of how the land is kind of set out in the grid structures. So in Texas, obviously, we have Spanish land grants. We kind of have a hybrid Jeffersonian system, while in Louisiana, they're going to have the pure kind of public land survey system, the Jeffersonian system, the section township range. These are important to remember too as we're talking about pooling, and really informs why pooling sometimes can be a lot easier and conceptually to think about in Louisiana versus Texas. So what is pooling generally? So pooling came about obviously to address the situation where an owner's tract is not large enough to be individually developed, absent a spacing or density exception. So essentially, they may only own a 10-acre tract of land. You sign a lease with them, go to drill on it. However, you can't get approval to drill a well there because the minimum kind of acreage necessary to drill that single well may be larger than that 10 acres. And so pooling came about as a way to combine all of those tracts of land in order to get approval to drill a well. Pooling also came about obviously as well because of the rule of capture, where you're pooling oil and gas from all these neighboring tracts. And so these neighboring owners would want to come together, pool their lands, all get paid for the drilling of this well that may be drilled on a different tract, but is kind of pooling oil or gas from under their tract of land. Pooling allows owners of contiguous tracts to combine their acreage, as we talked about. This can be either in the voluntarily or involuntarily in the compulsory pooling that we'll be discussing later, to form spacing units to meet state acreage requirements. There are different types of kind of units that you can be discussing. There's drilling and spacing units, which will be the minimum acreage necessary to drill a single well. You have proration units in Texas, and that's going to be that acreage determined by the Texas Railroad Commission that can be efficiently and economically drained by a well at a particular depth or horizon. And finally, you'll have pooled units, which is mainly what we'll be discussing today, and that's going to be those multiple tracts being combined to meet state spacing requirements. So also with pooling is you'll generally see pooling, unitization, and sometimes even communitization all used interchangeably. This isn't technically correct. All of these terms have a separate meaning. So pooling technically is just the bringing together of small tracts sufficient for the granting of a well permit under applicable spacing rules. While unitization is something different. Unitization is the joint operation of all or some part of a producing reservoir. Compulsory unitization normally requires a minimum ownership percentage to get unitization. And so it's very different than pooling, which is just these small tracts for just getting one single well permit. Communitization is going to be the federal equivalent of pooling. You cannot pool a federal tract of land without a communitization agreement from the Bureau of Land Management. Then the community lease is going to be something totally separate as well, and that is where a single lease may cover 2 or more tracts executed by separate owners as if they were joint owners. So this is generally referred to as pooling as a matter of law. Again, those are all separate terms that are generally used interchangeably, but they all have these separate meanings as we discussed. So forced pooling in Louisiana. Forced pooling is generally thought, it's generally going to be referred to as this compulsory units. In Louisiana, there's generally 2 common types of units. You generally have what's referred to as these compulsory units, which are going to be the forced pooled units. Then you also have conventional units. And so what makes these differences, the compulsory is mainly going to be focused on today, and that's going to be established by the Commissioner of Conservation, generally as to just a particular formation or interval, covering generally just a section of land, so kind of generally a 640 acre tract of land. While conventional units, you have 2 different kinds within that. You'll have a declared unit, and so if you've ever worked Texas before, this is going to be your common pooled unit that you're used to in Texas, where a unit's created pursuant to the pooling power granted in an oil and gas lease. Also in Louisiana, they have what's referred to as voluntary units. And so these units are generally created by an agreement of all of the parties coming together and pooling theirs. So you're going to need an agreement between all of the mineral royalty, overriding royalty, working interest owners, and there's even an argument that you may even need the agreement of all the surface owners in those units as well, even if they're burdened by mineral servitudes to form a voluntary unit. Again, the main topic we're going to be discussing today and going in on is kind of forced pooling, and so we won't be touching on those conventional units, but just wanted to mention that those also exist in Louisiana. So forced pooling in Louisiana, forming this drilling unit. So the Commissioner of Conservation generally designates drilling units whenever necessary to prevent waste or avoid needless drilling, even if the owners of oil and gas interests have not agreed to pool their interests. As we discussed earlier, the state of Louisiana cannot force pool federal lands, but any private-owned lands, state-owned lands can be force pooled when the Commissioner of Conservation deems it necessary, again, to prevent waste or avoid needless drilling. So why is it necessary for force pooled units? Excessive drilling is wasteful, obviously. If you think it's spindle top where there is all those wells on top of each other, that's not the most economic way to drill wells. And so force pooling kind of came about as a result of that, to prevent that excessive drilling and that unnecessary economic waste and physical waste. Force pooling also prevents, like I said, physical and economic waste. Drilling the wells under force pooling will be limited, and uniform well spacing pattern is established under force pooling. Also, you have the court of rights. The owner of a tract too small obviously cannot be granted a drilling permit, but they should still have this fair chance to recover their hydrocarbons. Denying him that right would be a confiscation, but permitting a well on his tract would be waste, and so force pooling came about as a way to kind of properly pay those small tract owners and make sure that they're getting compensated for the oil and gas that is getting drained under their tracts of land. And finally, force pooling is dealing with the situation where multiple landowners or lessees want to pool their leases or land for development, but there's others that are holding out. some parties may be non-consenting. There may be an issue where the leases do not have pooling language. And so forced pooling kind of resolved all of that situation where you don't need the consent of all the parties. You don't even need pooling language in the leases. The government basically tells you that it's necessary to force pool these lands and combine them all together. And so that's forced pooling. Again, forced pooling, owners have not agreed to pool their interests, commissioners shall require them to do so and to develop their lands as a drilling unit if he finds it necessary to prevent waste or avoid drilling unnecessary wells. This is taking directly from the risk fee statute in Louisiana, the exact language that is in the statute. The creation of these forced pool drilling units can be done either prior to drilling the proposed unit well, they can be formed while drilling the well, or even they can be formed after the drilling has been completed. Once a unit has been established, the commissioner will generally appoint an operator that will be deemed kind of the drilling owner to go extract the oil and gas from the reservoir. It's also important to remember too that forced pooling is generally going to be done as to a defined interval. So you're generally not going to see forced pooling done as to all depths under a tract of land. Generally what's getting forced pooled won't even necessarily be an entire formation. It'll be the lower Cotton Valley Reservoir A or the Haynesville Zone Reservoir A. A lot of that's going to depend on the field that the unit's formed in, but those are generally, you're just going to see it limited as to that particular reservoir within that particular formation. And that is going to be what is forced pooled. All other formations would not be pooled under that scenario in that unit. They may be pooled in a separate unit. So you can always have a lower Cotton Valley Reservoir A unit and then a Haynesville Zone Reservoir A below that unit. So you may have multiple forced pooled units on a single tract of land. And these are all supposed to cover then that particular defined interval that is going to be set forth in the pooling order by the Commissioner of Conservation. I know everyone's kind of familiar with pooling, concept of pooling, how it works, but I figured might as well go over it again. I'm more of a visual learner, so I made a kind of helpful graphic here. We have this drilling unit. We have 5 tracts of land on it: white acre, red acre, green acre, blue, and black acre. In this scenario that I've drawn up here, we'll just think of it that there's a vertical well drilled specifically on the tract of land of black acre. Under forced pooling, that well and all the production that is from that well drilled on black acre will be considered production from all the other tracts of land within the drilling unit. So that production, again, considered as production from all of tracts of land. And so any leases on those other tracts of land are going to be kind of extended, depending on if they include a pew clause, different language, but they're generally going to be held by that production from that well that's drilled on black acre, even though the well wasn't specifically drilled on their tract of land. I have a handy forced pooling order here, kind of a plat after the forced pooling order, just to kind of show you what it looks like in Louisiana when you forced pool a unit and how it kind of looks. And so here we have a proposed unit that's going to be formed for the Cotton Valley Zone Reservoir D unit. This is going to be the state unit B. And so you have this proposed unit that is getting forced pooled as, again, to that defined interval. And here again, Cotton Valley Zone Reservoir D. If you see here as well, the unit is going to cover that entire section that's set out forth here. So it'll be plus or minus about 640 acres of land that is going to be forced pooled together to drilling of a unit well. Generally, your pooling order set forth by the Conservation Commission is going to give you the right as a drilling owner to drill a unit well under this kind of proposed unit. If you wanted to drill further wells under this proposed unit, then you would have to file for additional approval to do that from the regulatory body. And those wells, additional wells that you would drill, would be referred to as alternate wells. Essentially, they're just not the first well drilled in the unit, so they're referred to as alternate wells. However, just because, again, that unit gives you the right to drill that one unit well, again, doesn't mean that you only can drill one well. You're just going to have to propose and file an application, drill any further wells within that unit. So with forced pooling, I mean, we discussed that one of the reasons it's done is because you have owners that refuse to sign a lease, owners that maybe sign a lease with another operator, and that's refusing to kind of work with this drilling owner to drill their well they want on this tract. And so how is kind of the risk of drilling that well resolved between all those parties. And so Louisiana, when they adopted forced pooling, they adopted the Louisiana risk fee statute, and it seeks to allocate the risk of drilling certain wells as between drilling owners and non-drilling owners. So in this case, drilling owners is again going to be that operator that wants to drill the well. Non-drilling owners is going to be all of those parties either who are unleased or have signed a lease with a separate operator, and that separate operator is going to be that non-drilling owner. So under the risk fee statute, the drilling owner has the option to give all other owners in the unit, again, the option, they don't have to, but they can give all other owners in the unit statutory notice and an opportunity to elect to participate in the risk and expense of drilling that unit well by the operator. Those parties who would want to participate would need to advance their pro rata share of the total anticipated cost of the proposed well if they want to participate. There's a lot of restrictions in here. The statute has a lot more on what type of notice is necessary, whether you have properly noticed the parties, when do you need to give them notice. All of that's in the statute. We won't be discussing that necessarily today, but that's all set forth in that risk fee statute. So if you have the situation where you've noticed these parties and say it's another working interest owner in the unit, you sent them notice, opportunity to participate in your unit well, they refuse to participate. Under the risk fee statute, you can charge that other working interest owner who refused to participate a risk charge attributable to for them electing not to participate. So essentially, if you're drilling a unit well, you can charge that non-participating owner a 200% risk charge of their carried share of the cost of drilling, testing, and completing the well. Again, so that's going to be for unit wells. So that's going to be for the first well drilled in a unit, kind of the well that's going to be generally thought of as kind of holding that unit. You can charge those non-participating owners a 200% risk charge. So that would mean generally as those costs for their pro rata share, the cost of drilling, testing, and completing, it would need to be at 300% of the total cost until that non-participating owner would be able to come into their share of the working interest of the well. If the carried non-participating owner is derived from an alternate well, so as we discussed, you have a unit well, and then for all further wells drilled within a unit, you have what are referred to as alternate wells. If you're drilling an alternate well and one of those working interest owners does not want to participate in your alternate well, which you would have to send a separate notice from your unit well notice. For each well, you're going to need to send a separate notice if they want to participate. If they refuse to participate in that, you've filed all the statutory notice provisions, then you can charge a risk charge of 100%. So again, the risk charge is going to be a little bit lower for these alternate wells versus a unit well, which would be the first well drilled in the unit, because obviously the risk is going to be a little bit higher with a unit well that you're drilling versus if you're drilling a second or third well within a unit, there's already been production, kind of the risk that the operator is taking on is a little lower. And so that's why that risk charge is going to be a little lower. If the owner of an interest in a unit elects not to participate in the risk and cost of drilling the well, the owner paying for the non-producing share of the drilling and operation of well can recover that risk charge. So that would be the operator, the drilling owner, is the one that's going to get to recover that risk charge only if the paying owner has made, like we said, an unsuccessful good faith attempt to have the other owner in the unit join in and to participate. It's also important to remember too that as we're discussing, we're talking about non-participating owners. If you have a working interest owner that does elect to participate, then this risk fee is not going to apply at all. They're immediately going to come into the well at their kind of 100% of their pro rata share. They are going to obviously pay their upfront portion of the drilling, testing, completion, and their cost for the well. Finally, proper notice is going to be required before any risk charge can be imposed. You're going to make sure you're following the statutory provisions regarding notice to a T. You want to make sure that you are following those to the letter of the law to make sure that you're able to charge these risk charges. What about unleased owners? So we were talking about non-participating owners on the last slide. That actually does not include unleased owners. For this non-participating owners, that is only going to be those parties who own a working interest in the lease. And so there's other operators who have signed a lease. That is not the drilling owner. That's what we're referring to there. Under the statute, a risk charge shall not apply to any unleased owners. And so unleased owners will generally get what's thought of as that free ride. If they elect not to participate, they elect not to sign a lease, they will not recover any portions until payout is reached. After payout is reached, those parties will be able to come in at their pro rata share of the well at their 8/8 portion. So that risk fee attributable to non-participating parties does not apply to unleased mineral owners. But again, an operator does have the right to withhold all proceeds of production from the unleased mineral owners until payout is achieved. So that's going to be generally forced pooling in Louisiana, risk fee, kind of how that applies. So Texas, although it's generally thought that Texas does not have forced pooling or compulsory pooling, Texas actually does have a statute that does allow for compulsory pooling. It may be very uncommon, but it is statutorily allowed, and it is available under what's referred to as the Mineral Interest Pooling Act, or commonly referred to as MIPA. Many people don't call it necessarily compulsory pooling. They like to refer to it as compulsory voluntary pooling, and this is going to be because of the strict requirements that are required to actually pool an interest under MIPA. There's going to be a very high threshold for a fair and reasonable offer prior to pooling under MIPA. And generally, if a true, fair, and reasonable offer is made to these parties, as you know, if you're going to make a very fair and reasonable offer to someone to pool their interest, it's generally going to be accepted voluntarily, and so you're not going to have to go through this compulsory process. And that's generally why compulsory pooling is uncommon in Texas. We'll also discuss as well, and when we get to production sharing agreements and allocation wells, well, why MIPA is really becoming less and less common as well. But the procedure for MIPA, generally it's going to depend on what type of MIPA that you're trying to accomplish. There's two different types that we'll discuss here in a little bit, but the general procedure is you're going to file your application to pool. The Railroad Commission examiner is going to issue a proposal for decision after your hearing with regards to kind of your application to pool. And then the commissioner is either going to decide to adopt or reject that examiner's recommendation and issue an order, either pooling, compulsory pooling, or not compulsory pooling the interest. Some of the requirements for MIPA, so you need obviously to have separately owned tracts embraced in a common reservoir with field rules. So you can't obviously force pool anything that's in separate reservoirs. You're going to make sure that's in that one reservoir. It's going to need to be 2 or more separately owned interests in the paration unit. Obviously, it wouldn't make sense if it's all single owned interest, but you're going to need 2 or more separately owned interests. Voluntary pooling is going to need to have not been done, and so obviously MIPA cannot be accomplished if there's already a voluntary unit there. You're going to need no voluntary pooling in order to use MIPA. An action by the commission is going to be, you're going to need to prove that it's necessary for them to enact this unit, this pooled unit, to prevent economic and physical waste. The reservoir that you're drilling in is going to need to have been discovered after March 8, 1961. So it's going to need to be a new reservoir, kind of a new field that's been discovered. And then most importantly, and this is the toughest requirement, is you're going to need a fair and reasonable offer to voluntarily pool. So again, you're going to have to make that fair and reasonable offer to those separately owned parties, those other interests, to voluntarily pool them. And again, as you know, as we discussed, if you're making a fair and reasonable offer to voluntarily pool them, generally they're going to accept it. If they do accept it, then you won't be able to use MIPA because, again, one of the requirements is no voluntary pooling. So I mentioned there's 2 different types. The first type we'll be discussing is the standard application of MIPA. So this is going to be the application generally made by an operator where they're trying to force an unleased mineral owner to participate. The requirements for this is you're going to have to prove, again, fair and reasonable offer to pool. You have to prove that the MIPA unit will prevent waste and protect correlative rights. And 3, that's going to be used to prevent drilling unnecessary wells. Generally, this standard application one is used when most applicants control at least 75% of the minerals, and there's possibly just one unleased tract that's preventing them from drilling kind of their intended horizontal well that they want to drill. That the geologist maybe told them, this is where really where the hot spot is. This is where we want to drill this well. This is where our production, this is where we want our take points to be. And there's just one unleased owner that's really preventing them from either making a pooled unit, a voluntary pooled unit, or just drilling that well in general. And so this is when you would use this standard application. You have that just one tough party that you can't get to agree. We have some examples here as well as kind of what is defined as a fair and reasonable offer. So one circumstance would be if there's a no surface use lease with at least the average royalty in the proposed unit with average bonus and the primary term no more than 3 years. And so if that's the offer you made to that unleased owner, they refuse to sign it, then that is going to be considered a fair and reasonable offer. Another would be if an option to participate as a working interest owner subject to a JOA. So if you reached out to the unleased owner, said, or even to another working interest owner that's refusing to work with you and say, hey, I want you to sign a JOA with the risk penalty no greater than 100%, and participate in drilling this well with me, and they refuse, that would be a fair and reasonable offer. And finally, another one would be a farm out option where the unleased owner maybe retains a 20% override in the well that's convertible to a working interest after payout. The courts have found that that is a fair and reasonable offer as well. Another type of MIPA is the muscle-in application. And so this one's going to be different than the standard where we talked about where you have those tough unleased owners to work with that are really preventing you from drilling your intended horizontal well. So in this application, you may have a production sharing agreement, or you may have an allocation well that you are drilling or intending to drill. And there's maybe a small tract owner that's you've purposely left out of your production sharing agreement or of your your allocation well that you're going to drill. And this small tract owner, because they may be difficult to work with, is now coming forward and saying, hey, you left us purposely out of this production sharing agreement, let's say, and we want to force our way into that production sharing agreement. We don't, basically our tract is unusable now. Maybe they have just a 2 or 3 acre tract and they're saying, hey, our tract's unusable now. You drilled this production sharing agreement purposely around our tract, didn't include us. Now they would come in with this muscle-in application. So in addition to the requirements of a standard application for MIPA, those parties are going to have to prove actual drainage of their tract. So they're going to need to get experts, prove that you would be, if you drilled that well under that production sharing agreement or that allocation well, that you would be actually draining oil or gas from underneath their tract, and or their minerals would be stranded. So again, that would be the other one where I discussed where maybe they own 2 acres. You've drilled a production sharing agreement just purposely almost circling their tract and didn't include them. They would be able to file this application and may meet this requirement here because their minerals are now stranded. One of the recent applications and kind of case law for this muscle-in approach was for riverbed tracts. There's some riverbed tracts that were trying to get included in to a production sharing agreement because they were purposely left out. They made the argument that our minerals are now stranded because they're underneath the riverbed, no one's going to come drill, and they were able to use this muscle-in application to get themselves included in that unit. So again, fair and reasonable offer is required for all MIPA applications. For the muscle-in application, some specific examples of a fair and reasonable offer. It's going to be if there's no change in operatorship. So all you're proposing is I just want my small tract in there. We're not trying to change operatorship. We're not trying to change anything. We just want our small tract included. That inclusion of that small tract will not significantly dilute the other tracts on a pro rata basis. So again, this is why it needs to be that small tract. If you own a 100-acre tract of land and you're trying to force your way into a production sharing agreement or an allocation well, you're going to significantly dilute all the other tracts, obviously. And so it needs to be a smaller tract generally that's getting added. It's going to be, there's going to have been a proposed oil and gas lease to this unleased owner. The applicant is going to have to be agreed to be treated as a working interest owner subject to a JOA with, again, a risk penalty no more than 100%. You're also going to have an accurate survey. You're going to know exactly where that tract is and what the acreage is and everything about it. And this is what makes it so difficult for those river tracts. Also, the applicant must attain a benefit that outweighs the burden to the operator. And so again, this is the example of the drainage of their tract is versus the equipment that the operator would need to expand their operations. So risk penalties under MIPA. So as we discussed with risk penalties in Louisiana, it's statutorily in there, the risk charge, as long as you have notice that 200% risk charge and that 100% risk charge for those non-participating owners. So it's very standard, very set out in Louisiana. Texas is not that way. In Texas, the risk penalties have been widely inconsistent and really seemingly arbitrary. All the statute says is that it must not exceed 100%. So really recent decisions have come out with, as long as your risk penalty is anywhere between that 0% and 100%, generally that's going to be allowed under the statute. Some evidence that's generally given weight to kind of the risk penalty that you're going to include in there. It's going to be how many wells are in a 5-mile radius not expected to reach payout. The actual chance of successful completion on your well. Are you drilling a well in a kind of a known field, or is it a wildcat well? The likelihood of the proposed well reaching payout, the standard risk penalty and JOAs in the area, how many nearby wells are considered to be uneconomic, and then many other economic risks, including market prices, regulatory challenges to drilling the well. All of this is going to be kind of used as evidence to the risk penalty that you ended up deciding on charging those unleased non-participating parties. So as we just went over, MIPA seems pretty difficult. It's not often used, and because of this, some substitutes for pooling have arisen in Texas because MIPA just lacks the teeth to do what you need to do, versus in Louisiana where those compulsory units really handle it all for you, and you don't have to meet that fair and reasonable offer standard. You don't really have to. It's really that fair and reasonable offer. In Louisiana, there is no fair and reasonable offer. You apply for that authorization to force pool those tracts, and that's it. As long as you own a great percentage in the well and the unit that's getting formed, you get authorization for that. Texas, as we just went over, it's different. You need to offer all those unleased parties. So all these substitutes have arisen to drill across tracts, units, or leases where there is no pooling authority. There's very little authority for a couple other things we're about to discuss, PSA wells and allocation wells, other than they basically said that production must be allocated with some reasonable probability. That's kind of the definition they're going with. There's some standards that a lot of operators like to use on what that means, the reasonable probability of allocating that production. One common standard is the amount of productive lateral on each tract from first take point to last take point. However, some other operators tend to use surface acreage possibly. Others want to use the number of take points. It's widely going to vary. So one of the substitutes for pooling in Texas is production sharing agreement wells. This is specifically a creation of the Railroad Commission to combine multiple tracts in the absence of pooling. This is going to allow an operator to form a production sharing agreement by obtaining consent of at least 65 of the working interest in the production sharing agreement area and 65% of the royalty interest owners in that production sharing agreement area. So really you just need 65% to agree to form a production sharing agreement. If the requisite consent is all obtained, then the Railroad Commission will permit the operator to treat that entire production sharing agreement area as a single drill site tract. So if we went back to that handy visual I had in the beginning when we were discussing Louisiana with the black acre, blue, red acre, that's what's happening here with the production sharing agreement. You're forming kind of a production sharing agreement area. If you think of it similar to a kind of a pooled unit or the drilling unit we discussed in Louisiana, it's going to be that single drill site tract. So operations, production from any tract within that area is going to be considered as production from all other tracts in that area. Production sharing agreement will also require Rule 37 lease line exception, because obviously you're going to be looking to drill across multiple tracts, across multiple lease lines. But it's important to remember here, if the operator owns 100% of the working interest, then they would be the parties that are kind of at notice for this lease line exception, and they can essentially just waive the notice and the hearing as their own offset waiver. If you do not own 100% though, again, it's important to remember that the other parties, working interest parties forming that production sharing agreement with you are going to need to approve of a Rule 37 lease line exception. Another scenario, besides production sharing agreements, maybe you are unable to get 65% of the working interest, 65% of the royalty owners to agree to form that production sharing agreement area. You may then drill what's called an allocation well. You may decide that's what's best for your operations. An allocation well is defined as a horizontal well that traverses multiple tracts which are not pooled and for which there is no separate agreement allocating production. So the main difference between an allocation well and a production sharing agreement well is that for allocation wells, you haven't agreed ahead of time how you're going to allocate production. Production sharing agreement, you're going to have set in that agreement how you're going to allocate production to all the different tracts based off of one of the methods that we'll discuss later. An allocation well is generally going to traverse unpooled leases or separate units. So commonly what we're seeing now for allocation wells is that you may have some old units with production that are still being maintained by that old well and old production. Now with new drilling technology, you're looking to drill a longer horizontal lateral, or maybe just a horizontal lateral in general than what was drilled in that old unit. And so in order to accomplish that, to drill that maybe 1, 2, or even 3 mile horizontal lateral, is you're gonna have to drill across multiple separate units or maybe multiple separate unpooled leases. And so this is where you would use this allocation well. Two main issues with allocation well is you're not agreeing on that production, how you're gonna allocate production ahead of time. And so under that standard of reasonable probability of allocating production, what is a reasonable probability basis for allocation? Courts haven't necessarily set. Also, does the Railroad Commission even have the authority to permit them? That's come up as well. There's been a lot of court cases about, one in particular, about whether the Railroad Commission even has authority to permit allocation wells. We won't be discussing that today, but very interesting to follow along on that and see how they end up deciding there. Allocation wells are also used in situation, like we said, no pooling authority, pooling provisions overly restrictive. You're also going to have the Rule 37 exception, the same issue that we discussed for production sharing agreement wells. You're going to have that issue with spacing and setback requirements. The bottom line is we still think it's a good idea, even if you're going to drill an allocation well instead of a production sharing agreement well, that you still try to get as many owners as possible to sign a production sharing agreement, even if it's under that 65% requisite requirement for a PSA well. It's just generally helpful ahead of time to get everyone to agree on how you're going to allocate production. So once the well is producing and you're paying those parties, that there's no disagreement, no fighting going on. Everyone's kind of agreed ahead of time on this is how we're going to allocate production. Also for an allocation well, tracts with differing mineral or royalty interests are considered as separate as different tracts. And so when we talked about production sharing agreement wells, where all the tracts are generally considered as a single drill site tract, for allocation wells, this is not the case. They're all considered different tracts, and surface ownership is generally going to be irrelevant for purposes of allocating production from wells for allocation wells. Authority for allocation wells, we talked about there is no Texas statute or regulation addressing production sharing agreements or allocation wells. There's a couple court cases that kind of lend credence to them, but there is no statute or regulation specifically addressing them. One court case is the Cockrell Texas Gulf Sulfur, explaining the doctrine of the greatest possible state granted, which permits the lessee to drill anywhere on a lease, including border to border, unless expressly prohibited by the lease. So essentially saying if you have a lease, you're allowed to go on there, drill anywhere you want, including all the way up to the lease line. Another case is the Magnolia case, explaining that the function of the Railroad Commission is to administer the conservation laws, and it's not the Railroad Commission's position to undertake the adjudication of questions of title or rights of possession. And so essentially, the Railroad Commission isn't in the job of deciding on how you're going to allocate production. It's their job to administer conservation laws. And so this court case basically said that the Railroad Commission can stay out of that adjudicating production and how you are going to do that, whether all the different methods. Railroad Commission's position on allocation wells. Railroad Commission has authority to permit commingling. These wells are developed as a response to, again, combining multiple tracts in the absence of pooling authority or the consent of working interest or royalty owners to pool their interest. The Railroad Commission will issue a permit to drill a horizontal allocation well in those circumstances where the applicant shows a good faith claim of a right to drill, which is satisfied by holding leasehold or mineral rights. All Railroad Commission applications, permits for allocation wells are going to include a disclaimer. That disclaimer is going to say The issuance of the permit is not an endorsement or approval of the applicant's stated method of allocating production proceeds among component leases or units. And payment of royalty is a contractual matter between the lessor and lessee. So again, as we discussed, Railroad Commission administers conservation laws. They're not in the business of adjudicating on how you're going to allocate production. They think that's a private matter between the parties, and the parties need to figure that out. If there's disagreement between those parties, then they need to go to the judicial system. So why do allocation wells exist? I've discussed it multiple times. Here's a handy, again, visual learner, handy graphic here to kind of show you. You may have 2 old pooled units. These units are still being maintained by production from old wells. Those units cover all depths. And then you may have a couple unpooled leases with no pooling authority. Your geologist tells you this is the heart of the formation. This is really where we want to drill this well. And if you're looking at this graphic, you're like, how are we going to do this? There's no pooling authority in this lease. There's 2 pooled units in these other ones that cover all depths. This is why allocation wells basically came about. This is the way to drill a well that's going to drill across all of these separate tracts and units and be able to recover all of that production that may have been missed if you weren't able to drill these wells. Allocation wells, again, it's important to note, they promote conservation by precluding drilling separate wells. So rather than you drilling 4 separate wells here, you're able to drill 1. And they're also going to prevent waste of oil and gas through the loss of reserves in dead zones or non-perf zones between tracts. So if you had, in this scenario, you tried to drill in the unpooled lease in that kind of northeast quarter, maybe non-perf between those pooled units, and then perfed again, and then unpooled lease, again, you're leaving oil and gas there to waste that could have been good and productable oil and gas. The main reason though why allocation wells exist is just the advancement in oil and drilling technology. So here, if you think of kind of old wells that were drilled prior to the advancement in horizontal drilling technology, you have these vertical wells that were just drilling on one track. They're drilling straight down. So you could put as many as you wanted on these different tracks, and they could all drill separately. However, now we all know there's horizontal drilling. And so now rather than drilling maybe 3 separate wells, you can drill 1 well and drill it across all of those tracks. And now you can recover all the production from all of those tracks. Also, you're able to cover, we touched on the Rule 37 exception, but that kind of setback lines, you're able to recover all the oil and gas within those setbacks as well. Under the old vertical drilling, those may have been unrecoverable, or even in before allocation wells, all of that kind of acreage and would have been unrecoverable without the kind of advancement in horizontal drilling and allocation wells. So that's Texas's kind of response to drilling longer laterals and horizontal drilling. So what is Louisiana's response? We just touched on Louisiana has these units that are drilling 640 acres. Well, as we all know, everyone drills wells, horizontal wells longer than 1 mile long now. You're seeing 2, 3, even longer than that laterals now. And so in response to this, Louisiana, here's the kind of memorandum that was issued by the Department of Natural Resources, the Office of Conservation in Louisiana, saying that they would allow cross unit wells. So what is a cross unit well? A cross unit well is a well drilled horizontally and completed under multiple drilling units. So we have a handy graphic over here that you can look and see. We had 2 old Haynesville units that were formed. You had unit wells, even horizontal unit wells in this case, that were drilled on those units. But now you want to drill a cross unit well. So you want to drill a horizontal well that is going to cross and produce from both of these units. And that is allowed now. You can drill these. And it's important to remember that the defined interval does not actually have to be the same for the different units that you're drilling across. And it may even involve units in different fields. So you could have a lower Cotton Valley zone reservoir A that maybe was defined in such a manner that that unitized interval also includes a Haynesville shale zone. And so if you have a Haynesville zone that's just south of it, you can technically drill a cross unit well across both of those as long as your target depth is included in that unitized interval from that force pooled unit in which the well is going to be completed in. The commissioners shall not authorize or permit a cross unit well when you are proposed to drilling less than 500 feet of perforated lateral in any unit. And so essentially, if you're going to drill a cross unit well, you're going to need to actually have a lateral that's going into each unit that's going to be generally longer than 500 feet. There is some circumstances where it may be less, but generally the requirement is that you need to be drilling 500 feet into each unit that you're drilling within too. And then I have the exception here if you want to read that as well. How do you obtain an application to drill a cross unit well? An applicant for a cross unit well needs to present evidence that both a majority of the owners having the right to drill, so both working interest owners, and if applicable, unleased mineral owners for each unit penetrated by the proposed unit cross unit lateral wells. The majority of them want to drill this cross unit well, and the operators of each unit, if the operators are separate, penetrated by the cross unit wells, consent to the proposed drilling of that well. It's important to know here, unlike production sharing agreement wells in Texas, where you need to have 65% of the working interest and 65% of the royalty owners agree, in order for you to get an application for a cross unit well in Louisiana, no royalty owner consent is required. Again, all you need is the majority of the owners having the right to drill, which would be working interest owners and any possible unleased mineral owners. It's also important to know that approval is not necessarily automatic on all your applications. However, they are generally approved as long as you kind of present this evidence to the Conservation Commission. So how is production allocated from cross unit wells? So unit production, as we discussed in a unit, so in your 640 acre unit, production is generally going to be allocated, or production is allocated on a surface acreage basis. So if you own a 10 acre tract, you own 100% working interest in that 10 acre tract, then your production is going to be kind of proportionally allocated based off of the 10 acres that you own, based off of the total acreage in the unit. So if there's 640 acre unit, you would own 10 over 640 of all production from that unit. Cross unit wells, unit production from each cross unit lateral will be allocated to each unit in the same proportion as the perforated length of the lateral in each unit bears to the total length of the perforated lateral as determined by an as-drilled survey. Big mouthful there. Essentially, the perforated length of the lateral is going to have to be set forth on this as-drilled well location plat that you're going to need to file. The percentage of that perforated lateral in each unit is going to then be set forth in how all those owners in each unit are going to share in production. So again, you have a 10 acre tract and one of these 640 acre units. As we discussed, that they own 100% working interest, they would get allocated production on a 10 over 640 basis. Let's say the perforated lateral is 55% in their unit and 45% in the other unit. In that case, for all production from that cross unit well, that owner is going to get 10 over 64 based off production from their unit, and then they're going to get further reduced then by 55%, because the 55% is the perforated lateral length in their unit. So that's how you're going to allocate production. And this is all set forth in statute, much different than Texas. This is the way that you are going to allocate production. This is how the Conservation Commission has set forth how everyone is supposed to allocate production. It's also important to remember that because it is going to be by this perforated length of lateral, that all cross unit wells, or each cross unit well, may have a different perforated length of lateral. You're not going to drill necessarily the same well over and over. You may have one that's in one unit 55%, the other 45, and another one that's maybe in one unit 65%, and the other unit 35%. In those cases, each well is going to have its own kind of allocation method and allocation of production based off of the perforated lateral length. And because of this, the Office of Conservation requires each cross unit lateral well to be separately metered, just so that you can report production individually for each of those wells that way. Production allocated to each unit is then shared between the owners in that unit on a surface acreage basis. We went over that on how you generally share surface acreage in each unit, and then you kind of allocate it after that based off of perforated lateral length. Also, as we discussed, you have to file that as-drilled survey. The survey is going to reflect the length of the lateral between the first perforation and the last perforation. So it'll give you that total perforated length of lateral. It'll also generally tell you the percentage of that lateral in each unit, or at least it'll tell you the percentage or the total length of the lateral in each of those units if it doesn't necessarily give percentages. It's also important to remember that this is perforated. And so if you have a non-perf zone to start the well or a non-perf zone anywhere there, this is all about perforated length of the lateral. Survey will reflect length of the perforated lateral on each unit. Each unit's allocation percentage is determined by dividing, again, perforated length of the lateral in that unit by the total perforated length of the lateral. Texas, how does Texas allocate production for allocation wells? As I mentioned, there isn't really a set forth guideline and standard way to allocate production in Texas. Again, it's different than Louisiana, where we just went over. There is one method, and this is how you have to do it. In Texas, there's all different methods. The Texas Supreme Court has not specified a formula for allocation of production other than allocation to each tract with, again, reasonable certainty. Again, that's kind of very subjective term, reasonable certainty. So here's some court cases explaining why and how that reasonable certainty standard kind of came about, and then a contrasting here. So with production sharing agreements, they're going to be a little bit different than allocation wells, where you kind of have these different methods of allocation. Production sharing agreements, you're generally going to go into them determining ahead of time how you're going to allocate production. Again, that's why they're production sharing agreements. But there's generally 3 different types of production sharing agreements, and I wanted to touch on those here. You may have a designated area production sharing agreement signed by owners within 2 or more pooled units or leases. This agreement generally is going to apply to 1 or more wells, because you're going to do a designated area, maybe a large area that you plan on drilling multiple wells across, and you're going to allocate how you're going to allocate production ahead of time. Sign this production sharing agreement between all the owners, or at least 65% of the working interest, 65% of the royalty owners. You also may have a single well PSA signed by owners within 2 or more. This is going to be limited again to the identified well set forth in the production sharing agreement. And you also may have a sharing well PSA. So these are all 3 different types of production sharing agreements you may have. So within those production sharing agreements and for allocation wells, as we discussed, there's different methods for calculating the interest in Texas. The 4 major ones that you generally see, though, are productive lateral length. So that's going to be similar to what we discussed across units in Louisiana. Kind of productive lateral within each tract, or Louisiana, as we said, each unit. In Texas, it would apply for each unit as well if you're drilling across pooled units, old pooled units. Then there's also percentage of horizontal lateral in each tract, the number of take points possibly within a tract, compared to the total number of take points along the lateral, and then surface acreage. And so we have some handy graphics here showing how, for each tract, how those 4 different methods are generally calculated. Here's one for the lateral length, showing if you have productive lateral, 8,000 foot effective lateral, 2,000 of it is tract D, and tract D is going to get 25% of production. There's the next one is the horizontal lateral, where you aren't necessarily looking at productive lateral, but you're looking at the total length of the lateral. And this one, if you have a 10,000 foot lateral, tract D is 2,000 feet of it, crosses through that tract D would get 20% production. You can also do it by take points, number of take points within a tract compared to the total number. So in this handy graphic here, tract D has 3 of the 8 total take points from this well, and so they would get 37.5% of production. So you can see the amount of production that they're getting allocated can vary wildly based off of what method you're using for allocation. The final method that you generally see is surface acreage basis. So the amount of surface acres covered by the lateral. So if tract D covers 20% of the surface acreage of the total surface covered by all the tracts that are kind of drilled by the lateral, then tract D would get 20% production. So again, these are just different methods that everyone may choose. Each operator generally has their own method that they prefer to use. There isn't necessarily one standard method, which again, different than Louisiana, where there is the one standard statutorily method of allocating production for cross-unit. So that concludes my presentation for today. We will be sending along an attachment of the AAPL affidavit of attendance and a handout later. And you should be able to then receive all of your AAPL credit for this presentation. If you have any questions about anything I discussed today, feel free to send me an email. I can answer those questions for you. Also, if you want to give me a call, that's great as well. But that will conclude the presentation for today. I hope everyone has a great afternoon, and thanks for joining us again.